Hi guys, welcome to my YouTube channel.
I had to put on my reaching hat. Hear me out. Thank you for clicking. Today we're going to be talking about Chad Daybell's hearing about the motion for joinder. The prosecution wanted to join Lori and Chad together and try them together. Lori said okay. Chad's lawyer objected, and this is what the hearing was regarding. Also, they had filed to get the case dismissed, Chad and his lawyer, and that has been postponed, which I doubt is even going to happen, like whatever. I want to talk about a reference to potential evidence that's going to be mentioned in the trial, which we didn't know about. I have footage of the hearing I want to play for you, and then also I want to talk a little bit about Lori Vallow's strange strategy, because it's oddly familiar to her strategies before, where I've covered in the custody cases with Tylee. I don't know, I think this is her idea. Before I begin, you guys know I have to give my thanks to my returning subscribers, old and new. Thank you. Just thank you, that's it. Not just focus on the thank you. If you are new here, hi. This is me. I wear a tinfoil hat and I talk about true crime and conspiracies. And oddly enough, this is definitely both. It's usually both on my channel. So anyway, let's get into it. So the hearing itself was about 20 minutes and I've taken out all the filler, and I'm just gonna give you like the highlights of the hearing.
In the case before the court, Chad and Lori Daybell are both charged with 2 counts of conspiracy to conceal, alter, or destroy evidence. Chad Daybell is additionally charged with 2 counts of concealing, altering, or destroying evidence. The evidence in question for all counts is essentially the same. That evidence is the deceased bodies of Lori Daybell's children, Tylee Ryan and JJ Vallow. Both of the deceased children were found on Chad Daybell's property in Fremont County, Idaho. They were found after law enforcement discovered a text from Chad Daybell to his now deceased wife, Tammy, matching that text with geolocation data from the phone of Lori Daybell's now deceased brother, Alex Cox, gave law enforcement the location of the children's bodies. The Daybells are charged with conspiracy because the evidence which the state will present shows that there was a plan between the defendants in regards to the fate of Lori Daybell's children. The evidence in this case, the state believes, will demonstrate that the concealment of Tylee and JJ's bodies are the result of the same plan and the same series of acts or transactions which constitute the offense for which both defendants are charged. The defendants' cases are assigned to 2 different judges. This is highly inefficient, as it requires duplicative work from 2 judges, their clerks, and their staff. This raises one of the most important issues in front of the court, as in most criminal cases, issues of evidence will be litigated prior to trial in these cases. It's inevitable. The trial court has varying degrees of discretion over the admissibility of evidence. As these cases are currently situated, it's entirely possible that an issue of evidence could be decided upon differently by 2 different courts. The state believes that could create automatic issues of appeal if that decision is beneficial to one defendant and yet harmful to another defendant. The witnesses in these cases are the same witnesses discussing the same evidence. That creates a great inconvenience and hardship on witnesses who live out of state. Witnesses in this case live in the various states of Idaho, Arizona, and Hawaii, and possibly others. Separate proceedings will create a great cost to the state in bringing those witnesses in for essentially duplicative testimony. Joint trials are particularly appropriate where co-defendants are charged with conspiracy, and the benefits of a joint trial in light of the allegations of conspiracy, as well as the need for the same witnesses and evidence, can outweigh other concerns. It's the state's contention that the rule for joinder should be construed broadly to allow liberal joinder to enhance the efficiency of the judicial system. There can be no question that separate cases requiring separate hearings will create more pretrial publicity. Consider the explosive nature of a story in which 2 different courts reach 2 different decisions on the same question of law or fact. Separate cases absolutely means more hearings, more media coverage, and more difficulty in finding a suitable jury. At the end of the day, the defendants must have a fair trial. If the defendants believe that joinder will prejudice them at trial, they may object and present evidence to the court on those grounds. At this point in the case, the court lacks enough information to make any such decision. Even if this court did find at some point that separate trials were necessary to protect the defendant's rights, at this stage in litigation, the requirements of justice and efficiency are better served by joinder of the defendant's cases under one court with one judge. A decision to join the cases now does not preclude the court from hearing argument under Rule 14 at a later time. The defendant always has the right, both defendants have the right to make that motion at any time prior to trial.
That would be a motion to sever that you're referring to?
Yes, thank you, Your Honor. A motion to sever under Rule 14. Finally, Your Honor, I would ask the court to consider the effect of keeping the cases separate, the effect that will have on the families of Tylee and JJ. They are victims in this case as well and have a right to be present at any physical proceedings it may have. Who knows how that will play out with COVID, but it's entirely possible that we will have many of these proceedings live. And I'd ask the court to consider the hardship on Tylee and JJ's brother, the Woodcock family, the Vallow family, and the Cox family in keeping these proceedings separate. Consolidating these cases creates less hearings and less travel for those victims, and as such, less hardship.
Thank you, Mr. Wood, for the argument. Mr. Pryor, argument in opposition.
Judge, I took the liberty of submitting State versus Nava to the court. I'm fully aware, and I appreciate Mr. Wood pointing out that Nava addresses 8A, but I think the analysis is the same. I think in good faith, I can't argue that the allegations, and I want to make it clear that they are allegations against Mr. Daybell and Ms. Vallow are similar in nature, and that under the prong of 8B, it applies, and the joinder does apply. The objection, Judge, that I filed talks about prejudice. Further, I appreciate that Mr. Wood recognizes that at any time in the future, I can file a motion for severance under 14 and say that trying these two folks in the same proceeding is highly prejudicial. Mr. Wood and I have discussed, and I'm not going to make a matter of this, but there's still some housekeeping that needs to be done in terms of discovery that Mr. Wood and I are going to privately engage in trying to resolve, and if necessary, we'll ask the court's assistance. But at this point, without all of the information in this case, I'm not in a position to argue severance on this date, and that's going to have to be reserved for a different date. But Mr. Wood's argument, Judge, to suggest a convenience to the court and expense to the county and the difficulty of witnesses is secondary. And primarily, Judge, the importance is Mr. Daybell going to get a fair opportunity to present his side of the story? And is it going to be able to be presented without any kind of prejudice or bias? Or are they going to infer anything from any other witness or any other defendant or anybody else that does not afford him an opportunity to fairly present his case? But the fact remains, Judge, that by linking the two of these folks together is still going to provide a modicum of prejudice. What I would ask the court to do is reserve a ruling on joinder, allow the argument to be made in terms of severance once Mr. Wood and I have resolved our discovery issues, and decide at that point whether or not we're going to proceed in a common trial.
I'm a little confused on, we don't get to severance without a joinder because right now we do have two separate proceedings before two separate courts. So I guess I don't quite follow the argument of reserving ruling on joinder and then argue severance later.
Well, and that's
actually where in all we are, you could call it severed because we have separate proceedings, separate judges right now.
I guess my feeling, Judge, is simply this, is that if the court joins the case, you're going to require the fact that I go through the analysis and we come back and there's going to be a continued hearing. Now the court understands it. Maybe I wasn't being particularly clear. I guess from my position is I would leave the status quo. And if at some point there needs to be a further ruling on the joinder, at that point we can go forward and do both of them at the same time. There is the opportunity without further action for a motion for severance in the future, Judge. Thank you.
All right, thank you for the argument, Mr. Pryor. Well, counsel, I've considered the motion. I'm prepared to make a ruling at this time. Mrs. Daybell's case, CR 222838, there was filed a notice of non-objection, and that is part of the consideration. Both cases have charges of conspiracy to commit destruction, alteration, or concealment of evidence. And in each case, or each complaint, I should say, that's pending in both cases, there's a list of overt acts that are alleged to have occurred in support of the conspiracy charges, and two separate sets of overt acts. When I review those complaints, the overt acts are identical as to both cases. Having two separate courses run in two different cases with two different judges could result in separate evidentiary rulings. I think quite concerning given our circumstances right now under our COVID restrictions and the difficulties we have even getting a jury trial at this point. The prospect of having two separate trials where two separate juries would have to be impaneled to try each case is concerning as well. I don't find that the prejudice at this point has been demonstrated that would be sufficient to prevent me from joining these cases. And so based on the analysis and consideration of the citations also provided by Mr. Wood, and also in due consideration of the new case that was cited by Mr. Pryor, the Nava case, I read through that as well. I do find the facts of that somewhat inapplicable to the issue I've got at hand. Upon consideration of all that, council, I am going to grant the motion to join at this time. As the parties indicated, that doesn't forego the possibility of a future motion for severance if prejudice is demonstrated by the defense in support of that motion. Mr. Pryor, any questions from the defense regarding the court's ruling?
No, Judge, thank you for your consideration this morning.
All right, thank you very much, counsel. I appreciate your preparedness this morning and your briefing and arguments. And if there's nothing further, then we'll be in recess.
The Daybells are charged with conspiracy because the evidence which the state will present shows that there was a plan between the defendants in regards to the fate of Lori Daybell's children.
See, first of all, they're charged with, oh my God, conspiracy. I need to stop being so dramatic. That's the universe telling me to shut up. Shut up. So there could be text messages or phone calls or emails or something that shows, as they said, that they conspired to kill the kids. That also brings me to Mark Means' request. Okay, this is insane. He requested toxicologies for the children. So that's very interesting because we know that also in the court documents, there's a long history of Lori over medicating children just to, you know, sedate them and ignore them basically. But also if you look here from an article from East Idaho News, Mark Means is asking for all audio and video recordings, communications, emails, text, social media posts, voicemails, videos, statements, pictures, police reports, agency reports, notes, charts, graphs, and files regarding the following people. And it is 17 people. You've got Lori, Chad, Melanie Gibb, David Warwick, Alex Cox, Zulema Pastenes, Charles Vallow, Adam Cox, Summer Shiflett, Melanie Boudreau-Pulowski, Ian Pulowski, Kay Woodcock, Larry Woodcock, Heather Daybell, other witnesses or potential witnesses, which is so broad, and what? Joshua J.J. Vallow and Tylee Ryan. This reminds me of the extensive witness list that Lori wanted for a simple custody hearing. And then there's a witness list as well. I'm going to just briefly put it here on the screen for you, and you can screenshot that if you want. Again, over 30 people that Lori wants to call in for a simple custody case. I think that this might be Lori's strategy to sort of like overwhelm the court, ask for everything, delay things, create unnecessary burdens. That's what she did all throughout her custody battle. I'll have it linked down below. There's also a very unprofessional social media post. I'll refer you to my last community post where I talk about Mark Means' Twitter post and what he said about Melanie Gibb, and he used a gif of like rats running, and he basically accused Melanie Gibb of being a rat, like running from a sinking ship, which kind of saying his clients on a sinking ship, I don't know, and basically saying that Melanie Gibb knows more than she's saying and was more involved than she's saying. And I also have a whole video going into why I think that too. Of course, I don't think that she was maybe involved with like the deed, but I think she turned a blind eye to a lot of stuff because she was brainwashed. That's my conspiracy, allegedly. Don't sue me. This strategy that she has where they're trying to do this sweep and involve as many people and do it, I feel like it's to slow down the process, to drag it out. I'm not quite sure. Maybe she's hoping she can post bail eventually and this whole thing will drag out with COVID and everything. Again, my conspiracy. I wanted to give you guys a quick little highlight reel of the hearing, as well as just like my commentary on it and just some things that I noticed. I would love to know what you guys think. If you have other ideas of why things are being done and said, I would love to know. Also, I am going to go camping for Halloween. I'm going to be outdoors in the middle of nowhere, so very socially distant and all that. So I won't probably have like a well thought out like video next week, although I am working on a deep dive video on this case. I have like an idea that I want to kind of go in on, and so I'm working on that. But I'll probably maybe upload like a funny kind of like vlog or what we did. If the footage is fun, I'll upload it for you guys. So hopefully that's not too disappointing, but also it should be lighthearted, fun, something just like a breath of fresh air, and then we'll get back into like the depressing stuff that I talk about. At the very least, I hope you guys have a fun Halloween, even if it's just hot cocoa with pajamas, cozy, watching scary movies, which honestly is what I want to do. But my husband wants to go camping, so I'm compromising, which is I guess something you do in marriages. Why am I air quoting marriages? Anyway, thank you guys so much for watching. Please subscribe if you haven't already. Stay safe, have a happy Halloween, and I'll see you guys in the next one. Bye.